podcast being produced by members of 12 Old Square Chambers employment team. This is part of a series of discussions on topics of current general interest. We should say at the outset that this is not intended to be for the purpose of providing legal advice and should not be relied upon as legal advice. If you need legal advice on a particular case, then you should instruct a lawyer. But today I have with me a couple of colleagues from Chambers, and we are going to address three hot topics in employment law. Section 44 of the Employment Rights Act and its impact on the pandemic. Also the hot news about the Uber case and the Supreme Court decision regarding the status of their drivers. And also we will deal with the IR35 changes. And before we start our discussion, I'd just like to invite my two colleagues, Sami Rahman and Trevor Drury, to introduce themselves. My name is Daniel Matovu. I'll start with Sami.
Morning, everybody, or afternoon, or wherever you are. My name's Sami Rahman. I'm an employment practitioner, have been for getting on to 24 years. The whole gamut of employment law since I started: discrimination, general knock-around, unfair dismissal work, really the whole shebang. And I've done the Court of Appeal, Supreme Court, High Court, you know, as old as the hills, even though maybe I don't look it, or maybe I do, I don't know. But that's me in a nutshell. I'll pass you on to my colleagues to introduce themselves as well.
Trevor.
Hello, my name is Trevor Drury. I have a background of 39 years now within the construction industry. I've initially trained as a quantity surveyor and moved into dispute resolution probably 25 years ago. So doing expert witness work and similar dispute resolution work. I was called to the bar in 2011 and I did my pupillage at 12 Old Square. I now specialise in employment law and building and construction disputes. I'll hand you back to Daniel.
Thank you, Trevor and Sami. Now, my name's Daniel Matovu. I've been doing employment law for over 30 years in practice and covered the whole range of employment subjects. Recently, I'm engaged in equal pay claim, but for today's purposes, that's not what we're going to be focusing upon. And I've also covered other areas of law, such as disciplinary work, but my main area of practice is employment law. I'd like to start today's discussion by looking at as we are in this pandemic, as to how people may use Section 44 of the Employment Rights Act, which is a provision that has been rarely relied upon in the tribunals, but has come to the fore at this particular time. And I believe, Sami, you've got a case, or you're engaged in a case in that area. Do you want to tell us a bit about it? You're
absolutely right, Daniel. I mean, in my 25 years or whatever as an employment practitioner, I've only really dealt with two Section 44 cases in all that time. It's not something that comes up very often. However, when we were in the pandemic, some of you may recall, there was an awful lot of talk in terms of TUC, teachers' unions and so on, about whether their members had to attend work, bearing in mind the risk of infection as a result of the coronavirus. And hey presto, I now have a case where that has arisen, where the employee or worker is in effect saying, this is before we had the first lockdown, but the advice was to work from home if you could, is in effect saying I couldn't attend work because there was an imminent risk of danger, and her second limb was she had to protect other members of her family, and therefore she wasn't going to attend work. Now, Section 44, as you remember, might be seen as the health and safety aspect of automatic unfair dismissal. In effect, the employee turns around and said, I can't do this or that, or I have to take certain steps because of health and safety, including not attending work. And in this case, it was, I'm not going to work on your premises because of the risk of coronavirus, which is topical. Obviously, I can't talk about the case in much detail because it's ongoing, but it's certainly an issue we've looked at. And the real question is going to be imminent risk of harm or danger, which is going to be the crux of the factual inquiry the tribunal is going to have to reach. And the difficulty is they've got to review the state of the medical knowledge or the scientific knowledge at that time as to the risk, and approach it twofold. They've got to look at subjectively whether the person really did have a fear, and objectively whether that was a reasonable fear in light of the state of knowledge at that time. And we all know from subjective and objective tests that it's a bit of a lottery as to where we're going to end up. Pause there for a minute. Certainly there's a move in Parliament to amend Section 44 of the Employment Rights Act to simplify the test of test in respect of imminent fear of danger or harm, in effect to make it easier to bring a Section 44 claim in the future. So certainly topical. Watch this space in terms of where we're heading. But of course, one has to understand the connection between Section 100 and Section 44, in the sense that in our case, it said, in general terms, that we either dismissed or didn't provide work because the employee on that two or one occasions refused to attend work because she thought it was too dangerous. So the argument then is that she suffered a detriment because of Section 44, she or he, whoever it may be. But those are the issues that are arising, certainly in terms of Section 44. I'll pass you over to my colleagues in terms of other issues. Certainly Uber is topical, bearing in mind how many, for example.
Can I just ask you a bit more about Section 44? I mean, for those who aren't so familiar with it,
yes.
Section 44, of course, deals with detriment.
Yes.
As opposed to Section 100, which deals with dismissal, a bit like the whistleblowing provisions, yes. Section 47B and Section 103.
Absolutely right.
And I mean, the reason why it's so rarely used is that the employee has to show that they reasonably believed there to be a danger that was serious and imminent. Absolutely. And clearly in this pandemic, one would think that the pandemic itself is sufficient evidence of a serious and imminent danger. So what more should be established?
Is it so clear? Because I don't think it is so clear. I think we have to look at the information that was available at the various stages of the pandemic. Certainly at the beginning it was social distance, but it's safe to go to work. Then it was work from home, if you can. I would say, arguably, the imminent danger aspect of it really only arises when we were in lockdown 1 or in lockdown 2, in terms of the information that was out there objectively. Subjectively, absolutely. So the subjective part of that test is relatively easy to fulfill, isn't it? Just like harassment, isn't it? Am I being harassed subjectively? I think I am. And then you apply the objective part of the test to see if that's reasonable in the circumstances. Certainly the first part of the hurdle is satisfied, but it will be the objective part of the test that will be under scrutiny in the tribunal. And I agree with you, it's certainly a better time or a better argument than we've seen for a long time in terms of imminent danger. But is it so clear? I mean, my argument to the tribunal will be, you have to look at the message and the level of information there was out there. Certainly a lot of us thought that providing we social distance in our day-to-day activities, we were generally safe to go to work. That was the information that was out there at that time, circa March, pre-lockdown 1, 2020. Yeah. So
I mean, presumably the tribunal will also have to look at the particular measures that the employer put in place.
Certainly the advice out there, and I think I sort of backed that up, is that employers who are going to require employees or workers to attend work, because you remember Section 44 also applies to workers, are going to have to carry out things like risk assessments, put into place basic social distancing measures, a cleaning regime. And if they don't, then they're certainly facing criticism, aren't they? Because in terms of that subjective and objective test, the more safeguards you have in place, the less likely there is to be imminent risk of danger, might be the argument.
Yes, but I think the important thing is that I know there was one union in the education sector that tried to provide blanket advice to their members, which is an entirely wrong approach, because each case is going to be fact specific, isn't it?
It would do the general indication that you could rely on Section 44, because you're absolutely right, that it's on a case-by-case, situation-by-situation basis, not a general sweeping position that if you go to teach in a school, you are going to be at risk of imminent danger or harm. So I think that's right, on a case-by-case basis, but I suspect that Section 44, certainly Section 44 is going to become a bigger feature of employment tribunal claims in the future. What will be more interesting might be, and I'm not going to say on the basis of how I raised this, is certainly the refusal to attend work because of imminent risk of harm, but superimpose on that any sort of disability that might be an issue. So the subjective aspect of it might even be easier to satisfy, perhaps, depending on your own protected characteristic. For example, if you have a disability that puts you at greater risk of harm. The other issues are going to be, obviously, if somebody's saying I'm shielding members of my family or my parents, that's a factual argument, isn't it? For example, if you don't live with your parents or the members of the family that you are shielding, it becomes difficult for you to say that I'm not going to do this, or I'm going to take this step pursuant to Section 44, because it's simply not credible. So there we are. So certainly I think watch this space. Watch the amendment that comes along in a few months' time. It's going to be far bigger than we think it is, certainly in the last 20 odd years that I've been practicing. But yes, I'll hand you back.
And as you mentioned there, Sami, I think the amendment is coming into force at the end of May.
Yes.
Whereby it's going to be extended to workers, because up till now it's limited to employees only.
Yes.
Which takes us really into the Uber case, because only this week.
Remember how that arose? That arose out of an authority that effectively said that Section 44 should cover workers.
Yes.
And that's how we ended up with a statutory amendment. So arguably it still covers workers now because you've got an authority that says it does. But we have a statutory basis now to argue that it will cover workers. And just segueing into the topics my colleagues are covering, and certainly I think, Daniel, you're covering, the increased prevalence of workers and, for example, delivery drivers in the middle of a pandemic. Well, as I said, we can see that it's going to be far more important than it has been in the past.
Yes, I mean, only this week we've just heard that Uber have announced that they are reclassifying all of their drivers as workers as opposed to self-employed. The Supreme Court decision, strictly speaking, only covered those employees who were involved in that litigation. And at one point, Uber were seeking to limit its effect to just the drivers who are involved in the case, which were about 25, with a lot of other drivers queuing up to make claims. But they've now decided that actually they ought to just declare that right across the board.
Well, I mean, I'm not surprised by this development. As I said, at the beginning of my career, or back in 2002, I did the Canada Life case, which is in fact arguing the same points that are now being run in the Uber case in respect of tied insurance agents. So I'm glad all these years later that we are at the zenith of that argument when I was right at the beginning of it all those years ago. So, and I'm sure you'll fill us in terms of your views on the Uber case, and if we've got anything to add, I'm sure you give us the opportunity to raise it. But yes, I think in terms of the development, certainly in terms of the impact of coronavirus and lockdown, one is Section 44, the other one is the impact or the absolute mushrooming of the gig economy, as we'd call it, then reining it in terms of worker status. And then that comes in very nicely with Andrew's discussion topic, which is going to be IR35. So there we are, Daniel. So I think in terms of time, Daniel, it's your slot if you're ready for it, if that's okay.
Well, I was really just interested that the Uber decision obviously was going to put great pressure on other similar gig economies. But now with that declaration, I think it's going to be very difficult for anybody in the gig economy to try and maintain that their worker, their drivers or whoever it is delivering supplies is self-employed. But it's still open to them to argue on the particular facts of their case.
Well, absolutely right. But you remember in terms of Uber, it was a level of control, wasn't it? I mean, if you wanted a job, it had to come through Uber. If you did the job, it had to be done through the Uber system. A payment had to be dealt with through Uber system. They had to comply with Uber's terms and conditions and the way they dealt with things. So, and it's the same, as I said, deja vu all over again. That's exactly the argument I ran all those years ago in terms of tied insurance agents, because they were absolutely tied to the insurance company as to how they did things. Control, control, control. And that's absolutely the theme that's come through in Uber, also in the Deliveroo cases. So wherever you're exercising control to that degree over, quote, workers or employees, or whichever way you want to call them, you are always at risk of a finding that they are workers. It's a level of control. And so the more laissez-faire you are, the less there is an argument about control, and the less there is a situation about mutuality of obligations. As you might remember from Uber's current press releases, they were still banging the drum about, drivers don't have to take the work. They can work as and when they want. In other words, they were still hankering back to the mutuality of obligations argument. But that's not it, is it? It's not just simply mutuality of obligations. It's when I want to work, I have to work the way you want me to work and comply with your terms and conditions and your processes and your procedures. And I'm bound by your decisions, for example, in terms of pay, refunds, and all those sorts of issues. So if you're going to exercise that level of control, you're going to be at risk of, in fact, classifying your workers as exactly that, at the very least.
But those who use these platforms, not just Uber, of course, but Addison Lee and Deliveroo and so on. The whole point of those platforms is to maintain control over the people they engage.
Absolutely.
Otherwise, they would lose a lot of business potentially.
Standards, maintain a corporate image. All those issues go to the same issue, the same question as to how relaxed you are. And I come back to, again, a case I did a long time ago now, again showing my age, case of Potter, which was about a delivery driver for a newspaper. Remember those? We had them some time ago. We don't have them anymore. Bits of paper that came to the door, if you remember. But it was about substitution, yes? And, if none of these drivers are able to substitute, or these delivery people or these service providers are able to substitute other people to carry on their work in their own control. Uber can, or the other organization can, but they can't. So they have to provide the service themselves. That's the bottom line, isn't it? They have to provide the service themselves. They can't substitute, and they're subject to a high level of control. And I think the implications of this are huge, not just in terms of the gig economy, as we call it, but the real gig economy, performing arts, entertainers. A lot of them are erstwhile self-employed, but in reality, they are workers. Yeah.
And of course, with that comes the whole raft of rights that workers are entitled to: national minimum wage, pension rights, and holiday pay, maternity, paternity pay.
And one of the things I didn't think about, and you're absolutely right, is they all have to be enrolled into the government, into a minimum statutory compliant pension scheme, and that's really the ticking time bomb, isn't it, in terms of all these workers? So it didn't occur to me actually, but I picked it up the other day.
And now they've picked up the Section 44 entitlement to bring a claim for that as well. So it's going to make big changes all happening at the same time. And I'd like to bring in Trevor at this point, really, because the IR35 issue is again something that is impacting the status of people. And Trevor, I just wondered if you could perhaps explain to people, how this will impact the changes that are being introduced, which I think have been postponed for a year already, and they're due to come into force next month. How these will, what impact these changes will make.
Thank you, Daniel. Yeah, this segues quite nicely from yours and Sami's discussion, actually, and it's like another raft of measures against self-employed people. So IR35, the changes that are due to come into effect on the 6th of April this year. If I explain first, well, IR35 was introduced to protect the exchequer by ensuring that individuals who work through their own limited companies, or what are known as personal supply or service companies, or PSCs, pay income tax and NICs, which are broadly the same as employees anyway. So they're trying to stop, I suppose, people getting around the income tax and NI situation. And this came about initially anyway in April 2000 and in the Income Tax Earnings and Pensions Act 2003. So what is a PSC? Or what does it do? So it's to reduce the individual's tax and NICs. It prevents the client having to administer a PAYE system. It saves the client employer's NI, and currently that would be 13.8%. It shields against personal liability for the person providing the service, and also eliminates the risk to the client, that is, of the individual will be categorized as employed. So he doesn't have any of the rights that an employee would have. So that's quite a large one for the employee or worker. So he doesn't have any rights as to unfair dismissal or any of those other rights. Mm. So this form of engaging people has been particularly prevalent within the IT industry, and I can also say within the construction industry as well. So what's new? So from April the 6th of 2021, the Income Tax Earnings and Pensions Act 2003 is amended by subsections 61K to 61X. So you can see how many amendments there have been. And the Social Security and Contributions Intermediaries Regulations 2000, we're at SI 2000/727. So a lot has changed. It applies to the private sector or to private sector entities other than small or those not having a UK connection. It shifts responsibility for assessing whether IR35 applies from the personal supply company to the end client. And if that does, it shifts the obligation to make deductions from income tax and NICs to the party closest to the contractual chain to the client. So if there's an intermediary, it applies to them, so they have to do the deduction. So this creates extra work and red tape for the end client, who will have to operate PAYE and pay, obviously, HMRC for all those deductions. So the regime has also already been in place since 2017 for the public sector. So it's already been running for over 3 years now. So when does it apply? So it's when an individual performs services to an end client. The client is a medium or large private sector entity. And the situation is one where those services were provided directly between the client and the individual would be considered an employee or office holder for income tax and NIC purposes. But as I said before, the worker has no employment rights whatsoever. Mm. So this applies to the individual if employed by an agency, an umbrella company, or similar third party. However, the system does protect against double taxation. So what is a small company and therefore excluded from the changes? We have to refer to the Companies Act 2006 for a definition of a small company, which also includes LLPs, unregistered companies, and overseas companies, which will need to satisfy 2 of the following. So it would have to have an annual turnover of no more than 10.2 million. That's quite a large turnover. A balance sheet total of more than 5.1 million, or the number of employees is no more than 50. So there's quite a few are going to be outside of that catch. If the company is part of a group structure, because you can see what's going to happen, they're going to set up limited companies to try and get around this. The parent company must also qualify as a small entity to fall outside the regime. So it can't set up a limited company as a part of its group structure to get around it. Joint ventures are similarly affected, and an entity will always be considered small in its first financial year. So it doesn't take effect until after the second financial year. Any worker or entity that contracts with the client have the right to request a confirmation that the client considers it qualifies as small within 45 days. So the ultimate client has to tell the worker whether it's in or outside. So how does the worker show that it is self-employed and not caught by the IR35 regulation? So the indicators are, so if you're in your contract, the recital in the contract should state that it's for services and not for the supply of a particular person. It contains a substitution clause permitting the PSC the right to send another person to do the work. Now the HMRC are latching onto this, that this is, if it's a sham, for example. The substitute must be paid by the PSC and not directly by the client. And the client should not have the right of prior approval. So you should have the right of substitution for yourself by anyone else without the client having any sanction. The clause allowing the PSC to have others to assist the worker. So you bring in others to help you. And again, the client can't stop you doing that. A clause ideally stating that the work is to be carried out for a fixed price. And this is going to be the difficult one for most consultants because most of them work for an hourly or daily rate. It's very difficult to actually have a fixed price to do something. I know as barristers we can do fixed cost work, but even for us that's quite difficult to estimate and only relates to small pieces of work. So that's going to be a challenge. And the clause requiring faulty work to be remedied at no cost to the client. So the worker has to put right any errors in his work free of charge. So what non-contractual indicators are there that would also assist? So limited control over the worker by the client. So Sami and Daniel, you've already referred to this the amount of supervision that a client can have over a worker. So here, the client can't have hardly any supervision over the worker. The client has no authority to move the worker from job to job. The PSC has professional indemnity insurance, public and employer liability insurance. It's showing that it is a genuine self-employment situation, that it has its own insurances in place. The individual uses its own computer or the PSC's equipment, computers being probably the one that we most likely are likely to see, and no employee benefits are provided, so pensions, healthcare, insurance, and so on. So that is a very brief canter through the regulations and the changes, which are quite immense actually, and it's going to be quite something for companies to get their heads around. And they're going to have to have done that already because it comes into effect only in a matter of weeks' time. So back to you, David.
Well, thank you, Trevor. I mean, I understand that a lot of contractors are actually being driven to set up umbrella companies, which then, of course, means they go on to PAYE and lose all the tax-efficient benefits of being self-employed.
Yeah, there are many benefits to being self-employed. One of which is you become your own boss, and you're not having to suffer the corporate world, so to speak, and get out of all the politics. That's one of the reasons people do go down that road. Another is they've had no option if they were made redundant. So if you go back to the financial crash of 2007-8, lots of people were made redundant and they had no choice but to go self-employed. And I suppose it was the start of the gig economy, wasn't it? So just people had no option to do this. And it's been really successful, hasn't it? It's worked for both employers and employees, that level of flexibility. But the problem now is that one of the benefits is clearly that if you earn a lot in 1 year, you don't have to take it as salary in that year. You can, you have to pay corporation tax, but you can hold that as reserves within your company, and you can then move that into the next financial year and draw it down. So you can avoid some of the higher rates of tax paid on salaries by moving it effectively from 1 year to the next. So that benefit has gone. And clearly, as I said before, the downside to this is that they have no employment rights. Pensions, healthcare, travel vouchers, whatever it may be, they lose all that protection, and obviously any social security that you would have coming out if you were made redundant from a job, you can't claim what used to be called dole or any of those benefits. So it has benefits being self-employed, but there's also a lot of downside to it. And I think the downside is now increasing considerably. And people are going to say, well, why would I take the risk of being self-employed anymore? I'll go and try and find a job. So if you combine that with what's going to happen with when the furlough scheme ends, there's going to be a raft of people that will be made redundant. Lots of companies won't survive. And you then pile this on, I think there's going to be a potential huge perfect storm at the tail end of this year. So I just think it's perhaps a bit misguided, this piece of legislation. The organisations that represent self-employed people have been campaigning against this. And although the government took the decision back in 2020 not to bring this in April 2020 as it was intending to do, it only deferred it to April of this year. And so a lot of people are rather disappointed by it. And I guess it goes to the fact that at some point we're going to have to pay for the pandemic, and this is just one of those measures that are going to be a bit of a tax grab for the exchequer. So yeah, we could be busy.
It remains to be seen whether it's going to have a great impact on the way contractors have been used increasingly by companies and organizations to avoid all the employment protection rights. Some of them may feel that the administrative burden and responsibility of trying to determine whether someone's inside or outside IR35 might deter them from this development of having more contractors and employees. But we'll have to see what the future holds. But I think we're going to end our discussion there. We only
further point, if I could, Andrew.
Yes, Sami, do.
Briefly, I came across something, and maybe you'll tell me if I'm right. There is one slight benefit in terms of IR35, unless I've got this wrong, which is that they can, although they can't offset their VAT in the way quite they were before IR35, they can in fact just pay the lower rate of VAT and thereby, if you like, have some financial gain, continued gain from being self-employed. Have I misunderstood that?
What do you mean by the lower rate of VAT?
The flat rate VAT.
Oh, the flat rate. That's linked to turnover, isn't it? The flat rate. Yeah. So it's whether their turnover has reduced. I don't know, but if you're operating through a supply PSC and you've either elected to be VAT registered or you're above the threshold, then you've got VAT still applies.
Okay. So not turnover. All right.
Yeah. Unfortunately, the end client or the intermediary has to take away the NIC and income tax, and they pay that then to the exchequer. But then that's dealt with through your accounts, and you're not double taxed on it. So, or so they say, anyway.
Well, yeah, we'll wait and see. But absolutely, thank you for that, Andrew. I'll pass you back to Daniel.
Well, thank you so much for listening, and I thank my colleagues Sami and Trevor for their contributions to our discussion. And we do hope that this has been of some value to you. And until the next time, thank you very much.
Thank you.
Yeah, goodbye.